Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer. This is another episode in our series entitled Buying Tenant-Occupied Property in a Just Cause State. And I am again joined by my friend Kaitlyn Jackson. She is an amazing landlord-tenant lawyer at Williams Kastner, Seattle law firm. Anything you want to add about yourself?
No, other than I've been practicing landlord-tenant law since about 2018, and general real estate transactions are part of my bread and butter. And so the idea of property transferring ownership when it is tenant occupied is part of my day-to-day.
So in this episode, we're going to talk about an issue that honestly I had never thought about. I've never even heard about it at a residential level. Kaitlyn said this is something that buyer brokers have to be aware of going forward. And as we talk more about it, she's taught me a variety of things already about this issue. Buyer brokers, yes. Property managers, as much as buyer brokers or more. So first of all, what is an Estoppel Agreement? And I'm going to tell you, if you've never heard of an Estoppel Agreement, you're okay, because they have their commonplace in commercial transactions, but we've never dealt with Estoppel agreements in residential lease agreements or any type of residential lease scenario. So Kaitlyn, what is an Estoppel agreement?
An Estoppel agreement is simply an agreement usually signed by a tenant that outlines the basic framework of the current state of their rental agreement and what it looks like. And it ties the tenant themselves to the details in that framework. And it includes very basic information like what is the current amount of rent? Is there any outstanding rent? Is there what utilities that tenant might be responsible for? Are the utilities up to date? Are there outstanding maintenance issues which have gone unresolved so far? Are there habitability issues that have gone unresolved so far? Really, really important pieces of an agreement that when somebody lives in a property.
Who are the occupants?
Exactly, right? So sometimes there are lease agreements that state who is subject to the terms of the lease, but then there are also sometimes other occupants outside of those individuals who live in the property. So having that information can be very important. In particular, in cases like now where we have a just cause state or a good cause state, where those other occupants may also have rights to the property.
That was something that Kaitlyn taught me about this topic. One of the reasons it's critically important to identify the occupants in the Estoppel Agreement is because under Washington law, this is statewide, if the landlord may not even be aware that a person has occupied the rental property, but if that person remains as a resident of the property for 6 months or more.
6 months, yeah. Mm-hmm.
Under state law, they acquire the rights of a tenant under the landlord-tenant law. Is that right?
It means that if the named tenant, the person who is subject to the terms of the lease agreement or rental agreement, if it's month to month, if they vacate, if they terminate their tenancy, the person who is the occupant that has lived there that is not part of the lease has the right to step into their shoes and become the tenant under certain circumstances. So the landlord cannot just terminate that person's occupancy. The landlord must offer them that opportunity to apply and step in.
Okay. So you just used a term, and I want to pick up on this term because you used the term step into their shoes, and I know you were applying it in the context of this person not named on the lease stepping into the shoes of the tenant. Mm-hmm. But when we think about this Estoppel agreement, there's a different explanation for stepping into their shoes that really drives the need for this Estoppel agreement, right?
Correct.
What is that?
It is when a new landlord or a new owner is purchasing a property from a previous owner and or landlord, they are stepping into that shoes and are exposed to all the rights and liabilities, and mainly from my perspective, the issue is the liabilities that previous landlord is exposed to. So that if the tenant has any claims that exist against the previous landlord, the new landlord is now exposed to those claims.
Okay, so I'm going to restate this. A buyer who purchases tenant-occupied properties by stepping into the shoes of the prior owner slash landlord, the new owner, the new landlord, inherits not only the right to collect rents from that tenant, but also inherits all of the existing liabilities, known and unknown.
Correct.
From that prior owner. So a seller might have represented to a buyer, oh, there's no problems in any of these units. Everybody's paying on time. Nobody has any maintenance claims. Nobody has any habitability issues in any of their units. And maybe none of that's true. And there are all kinds of problems. And that buyer could potentially sue that seller after closing. But 4 or 5 years from now, when that lawsuit is resolved, it will be of little value to the new landlord who has been dealing with these unresolved maintenance and habitability issues, or maybe who's lost the property altogether because tenants aren't paying their rent, etc. So how would a buyer, a residential buyer, and it could be a single family residence and it could be a multi-family property, how would a buyer acquiring an estoppel letter from the tenants, the existing tenants in that property, prevent that terrible outcome where buyer inherits unknown liabilities?
Well, hopefully it gets rid of the idea of the unknown liabilities. So one of the things that commonly is in existence in an estoppel agreement is a question of, are there outstanding maintenance issues that have gone unresolved? And hopefully the answer there that the tenant has signed themselves to and certified themselves to is no. And that way, when the ownership actually transfers, if there's some sort of claim that comes down the line, maybe 30 days later, 60 days later, oh no, this has been leaking for 6 months, or oh no, there's been mold growing in this, back corner of the house for a year. Well, the chance of that being something that the new landlord would be liable for, or that the tenant could viably claim, would be low, because that document, they've tied themselves to the information they provided under penalty of perjury or certified to the new owner is the truth about the property.
So it gives the buyer, the new buyer, landlord, a piece of evidence if they have to challenge a tenant's claim that the tenant's not paying rent because there are all these unresolved maintenance issues. If the tenant signed something days before closing saying there are no maintenance issues, everything's fine, but then 60 days later when they're not paying rent, they say, well, I'm not paying rent because there's all these problems that have been ongoing for a long, long time. This estoppel agreement signed by the buyer at the time of closing would be the new buyer / landlord's evidence to the court that the arguments that the tenant is now asserting should not be persuasive to the court. Right? That's the idea.
That's right. The term estoppel, meaning, it stops them from being able to make that claim.
Okay. So, Kaitlyn, residential scenario. If I'm the landlord, I want to sell, and I put an estoppel agreement in front of a tenant, is the tenant required to sign that estoppel agreement?
If it's not in the tenant's lease agreement that they are required to review and complete it, then no. However, there are ways that a landlord can do a rule change. If it's month to month, they can put a rule change in their lease agreement. If it's a month to month lease that says, hey, if you are presented with an estoppel agreement of this form, in this format, that you are required to complete it within X days of presentation, in the same way that commercial leases have something similar.
Okay, so month to month landlords could incorporate into their leasing requirements with their tenants and a commitment by the tenants that they must work with the landlord to execute an estoppel agreement on the landlord's request, at the landlord's request.
Yep.
And a term lease, when the term lease is going to be extended, then the landlord could add a provision into the lease extension that would require that tenant to sign an estoppel agreement in the future. Is that right?
Yep. And in ideal circumstances, the estoppel agreement is actually an exhibit to the term lease agreement so that everybody, when they execute it, understands exactly what information will be sought and what the tenant has to certify to.
Okay. Any best practices that you think should be incorporated by property managers, residential property managers going forward? When you think about how property managers protect their their landlord clients, not only on a day-to-day basis, but also with the expectation that those properties will be sold at some point in the future? Any best practices that should start to be incorporated by property managers?
There's many best practices, yes, but with regard to this issue, having a biannual, which is that twice a year? That's right.
Every 6 months?
Every 6 months. We'll do that. Every 6 months, going into the property and actually conducting an inspection with the tenant and signing off on the state of the property, similar to the information that would be filled out in an Estoppel agreement, making sure that the parties agree what the base rent is, what the liabilities are in terms of utilities, any outstanding maintenance issues, any outstanding habitability issues, really anything to do with that agreement that would be an important piece of information for both parties to be fully in agreement with. And creating that every 6 months, that's a great paper trail for if a property comes up with an issue, we can identify when that issue had to have started to come up, because we have all these documented Estoppel agreements or pieces along the way, or inspections with inspection reports along the way. That's one of the best tools that I can think of for making sure we resolve these issues. And if you remember, with state law stepping in and saying, hey, a tenant can bring in an occupant and have another adult occupant or a child or whoever come in and live there. And if they're there for a certain amount of time, they gain rights. Well, if you're doing that inspection every 6 months, nothing like that's going to slip under the radar without somebody knowing about it and making sure it's documented somewhere.
Because again, on the Estoppel certificate, the tenant identifies all of the occupants in that property.
Right. And so where that's come up, and I'm just going to use an actual example, is let's say a tenant does actually vacate and says, I'm terminating my lease agreement. And then the landlord appears at the property and it appears there's somebody there. And they're like, who are you? Well, if that person who's there says, I've been living here for 8 months or 9 months. Well, if the Estoppel agreement signed by the tenant is 3 months old, and it clearly states that they're the only occupant, it's more likely that we can get to the bottom of the fact that that might actually not be a valid occupant and be able to take legal steps quickly.
Okay. All right. So this is not a practice that property managers, residential property managers, are performing today. So we don't want to create the impression that property managers who don't do this right now are somehow negligent. But this is something that property managers and landlords should begin to incorporate in the management practices for residential properties moving forward. While it seems like it could be difficult to get a tenant to sign this agreement on a every 6 month basis, the conversation should be productive for the tenant as well. Tenant, this is your you're going to get to hear from me, the landlord or the property manager, every 6 months. And so if there's something that you've been wanting to tell me, but it slips your mind, well, this is going to be your chance, your reminder. Is there a problem I need to address? I can't address problems if I don't know about them. So I'm going to check in with you every 6 months. This doesn't mean you can't call me in between check-ins. Let me know if there is a problem. But every 6 months, tenant, you're going to hear from me, and we're going to document kind of the State of the Union, the state of the tenancy, right? We're going to document the state of the tenancy in a written Estoppel agreement.
Yep. Mm-hmm.
Okay. And so that could work to the tenant's advantage and the landlord's advantage. It's really just a way of formalizing the communications that should be happening.
And I will tell you that even as a tenant, I would feel a lot of relief that my landlord is going to come and meet me every 6 months, and we're going to make sure the state of the property is to my, needs and expectations. And if it's not, it's documented that I expressed that it was not, these things were wrong with it. And if that goes on for multiple inspections, that's going to build my case too. So it works, it cuts both ways. It benefits both parties.
If you have questions on anything we've covered in this episode or anything else, please ask me a question by visiting warealtor.org. Thank you for being a Washington Realtors member.